3, 2, 1, talk to me.
Welcome to Fair Housing. Now, I'm not going to give you an entire history lesson here, but let's just say our nation has come a long way. In the mid-1900s, civil rights laws aimed to promote equality. For example, the Civil Rights Act of 1964 paved the way by outlawing employment discrimination. The Civil Rights Act of 1968, aka Title VIII, also known as the Fair Housing Act, followed. The law extended protection to housing, banning discrimination in sales, rental, and financing based on race, color, religion, national origin, sex, disability, and familial status. The objective? Safeguarding every individual involved in housing transactions against unlawful discrimination and harassment. Today, HUD, or the Department of Housing and Urban Development, takes the helm in enforcing the Fair Housing Act, focusing on disparate impact, not disparate intent. In other words, your intention is irrelevant when it comes to fair housing, and unintentional discrimination still carries weight. So pay attention to this video because you could be violating fair housing laws without intending to do so. While federal law initially safeguarded 7 categories, including race, color, religion, national origin, sex, disability, and familial status, some local and state regulations extend protection to an array of additional attributes, including age, marital status, ancestry, citizenship, immigration status, primary language, source of income, sexual orientation, gender identity, gender expression, genetic information, and military and veteran status. Here's the golden rule: treat everyone equally. By doing so, not only do you minimize the risk of fair housing violations, but you also foster an environment of inclusivity and respect. It's worth noting that some states and local laws go even further, protecting individuals from discrimination and harassment based on their associations with protected characteristics, whether they're friends, family members, roommates, or other associates. Understanding the ins and outs of fair housing violations is crucial in creating a housing environment that's fair and inclusive. Let's take a closer look at 2 notorious violations: redlining and steering. Redlining back in the day was all about denying financial services and housing opportunities to folks of certain neighborhoods based on their race or ethnicity. The term originated from the practice of lenders drawing red lines on maps to outline areas deemed undesirable for investment, typically minority neighborhoods. Then there's steering, another big no-no. This one involves nudging potential residents towards or away from certain neighborhoods or areas of a neighborhood based on race, religion, or other protected classes. It's not just shady, it's illegal under the Fair Housing Act. In fact, here's a list of other illegal fair housing violations: falsely claiming that an apartment is not available when in fact it is, rejecting rental applications based on protected characteristics, failing to accept residents who participate in rental assistance or subsidy programs such as Section 8, discriminating in the rental application process based on protected characteristics, unfairly terminating a lease agreement due to residents' membership of a protected class, refusing to allow reasonable accommodation or modification for residents with disabilities, implementing blanket bans on renting to individuals with criminal history, screening rental applicants in a discriminatory manner, such as by asking intrusive questions about protected characteristics, retaliating against residents who assert their fair housing rights or participate in fair housing advocacy efforts. And some states even prohibit landlords from refusing to negotiate a lease based on a person's protected status. Plus, guess what? Even the notes you jot down in a resident's file can come under the microscope in a fair housing complaint. So here's the deal. Every single thing you say, write, or do could be used as evidence if a fair housing complaint pops up. That's why it's so important to keep things fair and square in all your housing dealings. After all, nobody wants to deal with the fallout from a fair housing violation. The consequences are no joke. Landlords and businesses can be sued, but keep in mind, you as an individual can also be sued and held liable as well. Consequences can include injunctions prohibiting the unlawful practice, recovery of out-of-pocket losses, attorney fees, damages for emotional distress, civil penalties, or punitive damages. The largest civil penalty in a housing discrimination case in U.S. history was for $10 million. And it's not just about personal conduct. You're also accountable for curbing discrimination and harassment within your housing community, whether it's stemming from your employees, contractors, vendors, or even fellow residents. Again, be mindful of how you communicate, especially in writing. For example, let's say you receive a noise complaint. Rather than saying, the resident in 304 complained about 305's kids being too loud, you may want to try, the resident in 304 complained about noise coming from 305. By not listing demographics such as gender and familial status, i.e. kids, you ensure your communication aligns with fair housing principles, adding another layer of protection should a fair housing complaint arise. From time to time, you may receive a request for reasonable accommodation or modification. But what exactly does this entail? And how does it relate to fair housing? A reasonable modification involves structural or physical changes to a dwelling, like adding a ramp or widening a doorway to accommodate a disability. Typically, the resident bears the cost, including restoration expenses, unless the modification was required by building code due to landlord negligence or if the housing provider receives government funding for affordable housing. A reasonable accommodation is an adjustment or exception of rules, policies, practices, or services where necessary to provide a disabled person equal opportunity to use and enjoy their dwelling. So this would be something like delivering packages to a resident's door, even if typically residents retrieve their packages from the office, or enabling TTS, text-to-speech, on your website. A request for reasonable accommodation does not have to be in writing. The person making the request does not have to use any specific words like reasonable accommodation. As long as they indicate a need for an exception, change, or adjustment because of a disability, it's considered a reasonable accommodation. Now, failure to respond to a reasonable accommodation request is considered unlawful housing discrimination. If you can't immediately grant a requested accommodation, it is your responsibility to engage in what is called interactive process with the requester. That means acknowledging that you have received the request and informing the resident of the steps you're taking to get the request into the right hands for approval. If it's determined that you cannot grant the request, you have to communicate with the requester to identify if there is another accommodation that's equally effective to meet their needs. So let's talk about assistance animals. According to HUD, an assistance animal is an animal that works, provides assistance, or performs tasks for the benefit of a person with a disability, or that provides emotional support that alleviates one or more identified effects of a person's disability. Housing providers cannot refuse to make reasonable accommodations when the accommodation is necessary to afford a person with a disability the equal opportunity to use and enjoy a dwelling. An assistance animal is not a pet, and there is no legal requirement for an animal to be registered or certified to serve as an emotional support. Once a request is made by or for a person with a disability-related need, you may deny the request if the following circumstances apply. A, the accommodation would cause an undue financial or administrative burden for you as the housing provider. B, the accommodation would constitute a fundamental alteration to the business. Or C, the specific animal is a direct threat to the health or safety of others. Given breed restrictions and the sensitivity of fair housing, the accommodation of assistance animals has to be determined on a case-by-case basis. And you need credible and objective evidence, not stereotypes or assumptions. Now, as for documentation, you can ask for documentation to verify the need for a reasonable accommodation or modification. However, if the need is obvious or already known, further inquiry is not necessary. And you should only request information that describes the needed accommodation or modification, or is needed to show the relationship between the individual's disability and how the requested accommodation or modification is necessary to provide the individual with an equal opportunity to use and enjoy the housing. Now, legally, that documentation can come from any reliable third party who is in a position to know about the individual's disability or need for accommodation. While this can be a healthcare provider, therapist, or social worker, it can also come from a non-medical service provider, a member of a peer support group, parent, child, or other relatives. Documentation can also be provided by the person making the request. Again, it doesn't have to be some official capacity. It can simply be proof that the resident or prospect received disability-related benefits such as SSI or SSDI, but it can also be the requester's own credible statement. The determination of whether the third party is reliable is determined on a case-by-case basis and may take into account how the third party is familiar with the individual's disability and/or the disability-related need for accommodation. Now, what you cannot ask about is a particular diagnosis or medical condition, the severity of the disability, medical records, medical history, other disability or medical issues unrelated to the request. Speaking of communication methods and visual representation also play a role in steering clear of potential violations. You want to opt for neutral terms like primary instead of using possible contentious ones like master bedroom. True story, I had a client who ran into a situation where they had two versions of the same floor plan. One had white cabinets and quartz countertops, the other had cherry wood cabinets and granite countertops. They priced the granite style finishes at a lower rate than the quartz countertop finishes. Looking from a business perspective, that makes sense. Quartz used to be more affordable until demand picked up. You now pay more for quartz, so you charge more for it. The problem wasn't the price. The issue was the leasing staff and the website referred to the floor plan with granite style finishes as the black renovation style and the other as white. Seeing those labels next to their associated dollar values ruffled a few feathers. And remember, fair housing violations are based on disparate impact. Intention is irrelevant. The good news is they ended up changing the labels to quartz and granite. One last thing I should mention about fair housing: screening. Your application requirements cannot shift from person to person. While your screening criteria may vary from property to property, within a single community, you must apply a fair and equal screening criteria. This means your requirements should not vary from applicant to applicant. In other words, know your approval criteria and don't make it a moving target. With that said, there is one type of screening that often toes the line of fair housing violations: criminal background screening. Let's say we have an applicant, and for the sake of this demonstration, let's call him John. Sorry to anyone whose name is John. John allegedly committed a crime, and he was arrested. This means that John was taken into custody by the authorities. The officer likely brought John to a jail where mugshots and fingerprints were taken, and they recorded the booking. However, until John sees a judge, be it a magistrate at the jail or a judge at a hearing or trial, no ruling has been determined. Even if John did commit the crime, John has not yet been convicted. For the record, you cannot deny an applicant based on a recorded arrest that did not lead to a conviction. Now, let's say John was convicted. The judge deemed John guilty for the crime that he committed, but years later, the case was sealed or expunged. Again, in many states, you can't deny the application because sealing or expunging basically rectifies John's reputation and eliminates that the record even existed. Lastly, in some states, you can't deny an application based on a criminal record that was processed in the juvenile justice system or while the applicant was a minor. And you cannot blanket ban all people with a criminal history. Denials related to criminal history must be directly related to someone's inability to be a good home renter. In other words, They must be a threat to the health or safety of others and/or the property. Consider the nature and severity of the crime, as well as the amount of time that has passed since the criminal conduct. This is definitely an area you'll want to have reviewed and approved by your supervisor. So, in closing, fair housing is no joke. Best rule of thumb, treat everyone equally. And remember, it's not about intention, it's about impact. Hope you enjoyed this video, and I'll see you in the next one.